Morning.
Happy New Year.
Happy New Year.
I am approaching this morning on Robert Moore.
Moore?
Yes, Moore.
Oh, Moore with an M. Okay. Oh, he's not.
Oh, no, that's somebody else. They both have the same last name. Yeah, I have another case that got moved to Friday. Her last name is Moore.
Is this is a new case?
Yes, it is.
16, Your Honor.
You mind bringing him up?
Yes.
Oh, this is the case. Okay. Okay. Right. All right. Good morning, Mr. Moore. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 31st, 2024, the officer initiated a traffic stop for the defendant's vehicle speeding 61 miles per hour in a 50 mile per hour zone at the 6100 block of South Highway 225. The officer made contact with the defendant, driver of the vehicle, and the officer observed an odor of marijuana. The defendant stated someone else possibly smoked marijuana inside the vehicle, and a PC search was conducted. The officer located 3 individual packages with a green leafy substance known to be marijuana based on training experience. The officer located these packages inside a red backpack on the back seat of the vehicle, and the marijuana was weighed, and the weight was 2.87 ounces.
Did you say, you said speeding? Did you say
61 and a 50?
Got it. Okay.
And if I may, the issue that I have with the PC, so in regards to the speeding allegation,
All right, pause right here. This is where things get legally interesting. The officer smells marijuana, which under Texas law can establish probable cause. But here's the twist. The defense claims the substance was CBD, unopened and vacuum sealed. That raises a big question. Can something sealed really create odor strong enough for a search? This is one of those gray areas where courts often say probable cause doesn't have to be perfect, just reasonable. What do you think? Should CBD and marijuana still be treated the same during traffic stops? Drop your take in the comments.
there were 2 cars in front of my client prior to him being stopped. It was 3 a.m. in Pasadena. He had the nicer car and was pulled over. And also my client explained to officer when he asked him about the smell in the vehicle, he did tell him that he had CBD in the car. He said that I had 3 packs. I just purchased it. They're in my backpack in a bag. They were unopened at the time. The officer did take the bag so that he wasn't, he didn't know how CBD looked or smelled, so he was just going to find it to be marijuana and would take him in for that, even though my client did prove up the fact that it was CBD in regards.
But if it's CBD and it's unopened, it wouldn't smell, right? Because it's vacuum sealed.
Well, no. He said he smelled something in the car, but the substance that he found in the packages, they were unopened, and those were CBD. That's what he said that he found to be marijuana. But my client let him know that this is CBD. It's in my backpack. When you search, you're going to find it. It's going to be in there. But I purchased it earlier today from a smoke shop. And so when the officer did retrieve them out of the backpack and asked about it, he's like, well, I can't tell the difference between, what CBD and marijuana is. I only know marijuana. So I'm going to have to take you in on that.
What form is this CBD in?
It was like in a little,
Is it?
it was a flower. So
It is a flower.
So I do know that the CBD flower and cannabis flower, they look very similar. So
Your Honor, if I may. So as the DIMS establishes, so the odor was enough from the search, and finding that leafy substance is enough because upon further testing, it may or may not. But just for the purpose of probable.
So I think for probable cause purposes, I think it's enough because the odor, right? Now, they're going to test it. If it tests different, then there we may have an issue.
Yeah.
But as far as probable cause, and your record speaks for itself, Mr. Moore. Anytime you get pulled over, what's going to happen?
They gonna search me.
You know what I mean? This is what? 1, 2, 3, 4, 5, 6. 6th marijuana case. Anytime you get pulled over with your record, what's going to happen? Every single time. So why give them a reason?
Right.
Really, we keep coming back and forth and back and forth and no. Can you run his license if he has?
Eligible, Your Honor.
All right, I'm not going to put any conditions, just be careful. Don't pick up any new cases because I'm going to lose it at that point. You've got a great lawyer, listen to her, she'll take care of you. If she tells me she can't get a hold of you, I'm going to revoke your bond. Just be good, don't pick up any new cases. If you're going to drive, make sure you have insurance, car insurance, all right? Okay, guys.
Thank you.
Yes, ma'am. All right. Hi.
Judge, I have an Anisha White on the docket.
Okay, it's getting up there, but
Yes.
not up there.
So I just asked the state to eval the last fine they did. I would like to get a trial date, but
Of course you can.
okay, then I'll do that.
Sure. Yeah, just talk to Ramona, whatever you want.
Thank you, Judge. And
of
then
course.
I also have a Coriel Dixon on the docket.
How is Miss Dixon doing?
She's doing well, Judge. She
Did you finish it yet or what?
No, her last class was on 12/19. Then they took a break, and they come back tomorrow. She brought her over the break homework and study guides that she's filled out.
Okay.
So she's been working on it. I asked her tomorrow when she goes back to figure out exactly how long it's going to be before she hits the test, because she took the evaluation test already. Those results aren't back yet because that was right before the break. So we should know in the next couple of days, hopefully.
So let's set it off a week to see, and then we'll go from there. And then, we can do just a longer day, huh?
Yeah, sounds good. Thank you,
Okay,
Judge.
thanks, bud.
There was a video that just found in this case.
I know, I saw it. That's why it's. So what, come on up.
Good morning, Judge.
Is he here? Is that him? That's not him, right?
No.
Okay.
My understanding is that he is still home with a sick child. I do have a doctor's note that I showed to the state. I don't know if that's sufficient for the court, but that's.
Okay. Yeah, it's just regular.
Thank you, Judge. Can you speak?
Yes, ma'am. You ready? Hey. Come up, Mr. Harrison.
Now watch the judge's tone shift. This isn't just about the case anymore. It's about behavior. Repeated bond violations, especially involving alcohol, are a huge red flag in court. Judges see this as someone testing the system, and patience runs out fast. This warning isn't for drama. It's a final notice. Rehab, jail, or stricter conditions are all legally on the table here. Do you think tough love judicial warnings actually help, or do they come too late?
Yeah.
Was today his regular setting, or was it a setting that we brought him in because he has bond violations?
This is regular setting.
Okay.
We had accepted the plea offer and we're ready to move forward today before I got that email.
I have here that you have bond violation, Mr. Harrison, in that you were continuing to use alcohol. You are entering into a probation now, and I'm warning you that if you test positive again, I can amend your conditions, and I will, to put you into a rehab facility. And I can take you there kicking and screaming, and I don't care what is going on in your life. But if you continually show me that you cannot stop, then I'm going to do it my way. And I promise you, you're not going to like the way that I do it. It is a minimum of 9 months in treatment if you respond well. Do you understand? But it could be in an inpatient facility for up to 1.5 years of your life spent with me in jail. Do you understand? If I didn't get your attention enough last time, heed this warning now, because you will not get another one. You are charged with driving while intoxicated, second offense. They have agreed to reduce it to a first. And I hope that you thank them because thereby you are now not going to do 5 days in jail because that would be the mandatory minimum for you if you plead on a second. But I'm going to tell you now, I'm going to keep you on a very short leash. And one false move, they're going to file a motion to revoke. And if they prove it to me that you violated probation, get ready. For you to complete what are you pleading to is 180 days in jail to be probated for 15 months. As part of the conditions, you will do a repeat offender DWI education class. 2 victim impact panels. You must also do a TRAS. This TRAS is an evaluation to see what other conditions you may need. If they assess other conditions, which in my guess they're probably going to, you must fulfill those. It can be so much as intensive outpatient treatment, supportive outpatient treatment. Because you're continuing to drink while you're on bond for this case, it may very well say that you may need inpatient treatment. I don't know. But that's what you're agreeing to now. Do you understand? No drugs, no alcohol, random urinalysis. You must maintain a guardian interlock and a $100 one-time donation to MAD. One more thing that you must recognize here, that there is a requirement for a no breath test refusal. If you are driving in a car and you get pulled over, an officer asks you to submit to a breath test, you must submit to it. If you fail to, then they're going to take you to jail and you're in violation of this probation. Do you understand? You give up many rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this offense, it will go on your record. This is number 2. What happens the next time, Mr. Harrison? If I had one strand of hair, every time someone told me that it wasn't going to happen, I would have flowing, beautiful locks. You need to know what happens if you get pulled over again and you get charged with another DWI. What happens next time? You will be facing a 3rd-degree felony. You'll be facing a minimum of 2 years in prison, a maximum of 10 years in prison. If I were you, if you even have a sip of alcohol, I wouldn't get into a car because you were taking a humongous risk. You tell me now, well, it's not going to happen. You told me you weren't going to consume. Here we are. We've got you on a bond violation. Goes in here, goes out here. The only thing that matters are actions. Your words mean nothing. Actions speak louder than words, Mr. Harrison. How do you plead to the offense of driving while intoxicated, guilty or not guilty? I'm going to find you guilty. If you violate this probation, I'm going to issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out here in Orange. We're going to have a conversation as to whether you violated this probation. And if you did, you were looking at 180 days in jail. Do you understand? Okay. So the other thing that we have to do is the fines and fees for the DPS surcharge. It's a first. So it's a $3,000 fee, but let me ask you this. Is this a 0.15 or above?
Your Honor.
And is it alleged? Is it alleged on the information?
I believe it's alleged to be a 0.15.
You should be walking out here with a $6,000 surcharge, but because they reduced it to a first, it's now a $3,000 surcharge. You must pay that in addition to the court cost. If you don't, for every $100 you owe, you will sit 1 day in jail. Do you understand? Okay. How do you plead to the offense? I will find you guilty. I'll send you to it. Good luck, sir. Thank you, Ken. All right.
Judge, are you issuing a no-voting message?
He has the portable device at this time.
Okay.
His license is suspended until February 18th.
Okay, yeah, we need to do a no driving affidavit. You are not allowed to drive. I don't care what you're doing in your life. You'll be signing an affidavit with me today that you're not driving. I hope you're not driving at all. Take it seriously, Mr. Hunter, because if I catch you driving, get ready. Okay, so if he decides to, if he wants to drive, he needs the interlock before he even gets into a car driving. So we have to amend conditions to be able to do that. So you can't just start driving. You cannot just start driving. You are required to have an interlock in your car. There is a paper that we sent to DPS so that every officer in the state knows that if you drive, you're supposed to have an interlock. You get pulled over and you're driving and you don't have that interlock, they're going to take you to jail. You understand? Okay, talk to Kim. She can help you out when that time comes.
Thank you so much.
Thanks, Kim. So the 3,000 plus the court cost, who's gonna pay all? Are you Miss Troyanne Marie Britton?
I am.
Miss Britton, you are charged, I'm sorry, you are wanted out of Georgia, Fulton County, Georgia specifically, for possession of a firearm or knife during a commission or of an attempt to commit. I don't know what, it just ends there.
Judge Fleischer.
To commit certain felonies. Your lawyer has asked for me to set you a bond. I don't know. I don't know anything about you. I've never met you before. So I got to see who you are as to see whether I'm going to set you or not. You know, one of the main things is, are you a danger to our community? Number one. Number two, if we set you a bond, are you really going to go back or are you just going to take flight? Those are the things that we're really concerned with here. Amy, tell me about Miss Britton. Or Katie, or is it you or anyone?
Yes, Judge, I'm here.
Okay.
I would be a little bit concerned, Judge. I am seeing 2 failure to appears already on her criminal history. I see a possession of a pistol by a person under 18.
Wait, what was
There's
that?
A possession of a pistol by a person under 18. Interesting charge. And then I see a failure to appear. I see possession of a controlled substance, marijuana charge, willful obstruction of law enforcement officers, and aggravated assault, theft by receiving stolen property, driving without a valid license, another failure to appear.
Is that
So I am a
four
little
failure
bit
to appears?
concerned.
That's 4 failure?
I'm seeing 2 failure to appear, Judge.
Were they fugitive cases or just open cases elsewhere? And where is all that history from?
So I can't tell, Judge, if it's a fugitive case or not. I see that it's out of Fulton County. Let's see. I see Atlanta Police Department. It looks like most of these are out of Fulton County, Judge.
How long ago are the FTAs? Is it a recent or?
So one is from 2023 and the other one is from, trying to look for a date, Judge, is from 2024, from 6/28/2024, it appears.
And I'm assuming that 6/28 one is the one that's holding her right now.
It might be, technically the warrant that we have written down is possession of firearm. So it doesn't specify whether it's a failure to appear warrant
You know
or
when the
not.
hold was placed?
Let's see.
She was booked on our.
It looks like it,
7.
I'm sorry, it looks like it's from February of 24. Yeah, it doesn't, like I said, it does not specify that it's for the failure to appear.
Judge, so she hasn't been before your court. This is one of those cases where I'm not asking for a PR bond. I'm asking for a bond that would ensure that she turns herself into Fulton County. I've talked to her about your requirements if you were to set a bond, how that affects her, how that affects the bond. She needs to present herself. She's got criminal history, I'll give you that, but she hasn't been before your court before. We're asking for an opportunity for her to go turn herself in. She's willing to do that within 14 days and show proof of that. If she doesn't turn herself in, well, then I'm not going to say, but at this point, it sounds like possession of firearms are most of the cases that she has.
All her cases are dangerous cases. Assault, ag assault, possession of a pistol. Now she's got a pistol case, committing certain felonies. We don't even know what the felonies are. Do you know?
No, Judge, not at this time.
I only heard of
A bunch of FTAs, at least 2 other FTAs. Now we've got a third. What? You really want me to set you a...
This moment is heavy and honestly heartbreaking. At just 19 years old, the judge is weighing public safety against any chance of trust, and the prior failures to appear tip the scale. Legally, bond isn't about fairness or sympathy. It's about risk. When extradition is involved, especially with violent or firearm-related charges, courts almost always err on the side of caution. Do you believe age should matter more when deciding bond, or does a record speak louder than youth?
Bond? I want hair. Not going to happen. No, at some point, we got to say when. But, you know, you've racked up a bunch of criminal history. How old are you? How old is she?
She's, I think she just turned 19.
19 and all this?
Was I right about that, Troy?
Correct. I'm 19.
Yes.
Absolutely not. I'm in shock that you're 19. And Katie, how many priors are we talking here? At least like 6, 7, 8?
It appears so, Judge, yes.
No, I'm sorry, but I just, you scared me, Miss Britton. Really, I don't think that I could trust you. I think if I set you a bond, it's something is going to happen, or you're just not going to go back. And I'm sorry, I can't.
Understood, Judge.
Right. The good news is that you've made bond on your other case here, so the time is ticking for George to come get you.
She needs to waive today if she wants that to happen.
I'm sorry.
She will need to waive today.
So the process is that you can either waive or you can fight extradition, in which case they will get a governor's warrant, which will take up to 90 days. But if you waive extradition, that gives Georgia up to 14 days to come get you. And if they don't get you within that 14 days, then Harris County releases you. But at 19, with as many priors as you have, including 2 failure to appears, you really scare me. And I don't think that it would just, that it's time to pay. I just can't trust you, Ms. Britton. Sorry.
Would you consider any amount?
No, I mean, all that, and you're 19, it's hard enough being a person of color in today's society. And now with all these priors, all you're doing is you're digging yourself a grave. You're making yourself unemployable. You know, this life can be a great journey where you buy nice things, you take nice vacations, you get married, you have kids, and they come up to you, hey, I love you, mommy, I love you, daddy, you know? Or it can be a rotten, miserable of an existence where you're in and out of jail at 19. All these serious priors, come on. Stop. It's time to grow up. And me giving you a bond now would be just enabling you and telling you what you're doing is okay. It's not. And now we'll wait for Jordan to come get you. Thanks.
Okay. Thank you, Judge.
All right, you are Aguilar Barrera.
Sí, soy yo.
Yes.
Okay, sir, you are charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. The officer initiated a traffic stop after observing the defendant failed to maintain a single lane and run over a curb in an underpass in Harris County, Texas. Upon contact, the officer observed unsteadiness, slurred speech, bloodshot eyes, and a strong odor of an alcoholic beverage. The defendant did not consent to standard field sobriety tests. The DIC was read, and the defendant refused a blood and breath sample. A search warrant was signed and executed.
Can you see any prior DWIs? And have you see it?
I have no license on file, and there's no prior DWIs.
Okay. Mr. Aguilar Barrera, I don't know what your immigration status is, but if you were in this country without permission and you go to jail long enough and immigration finds you, they will put an immigration detainer on you and you will be stuck in custody until this case is over with. And then you will be shipped off to immigration where you will sit for another 6 to 9 months. You do not have a Texas driver license. You are not allowed to drive. Do you understand?
Sí, señor.
Yes, sir.
I don't care what's going on in your life. I don't care if you need groceries. I don't care if there's a burning building and you have to save 50 kittens. You drive. I can have a contempt hearing. I can hold you in contempt, slap you with another 6 months in jail and or a $500 fine every time you drive. You will be signing an affidavit with me today promising me you're not going to drive. Do you understand?
Sí, lo entiendo.
Yes,
I'm also ordering you as a condition of your bond not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're consuming any kind of alcohol or illegal drugs, likewise, you will go to jail. No more PR bonds for you. You got out of jail quick because we gave you a PR bond. If you pick up a new case or violate conditions, I will revoke your bond and you will be stuck in there for at least 6, maybe 10, maybe 12 hours. And that's when immigration will put their clutches all over you. This is the only warning you're going to get. Heed this warning.
Yes, sir.
How old are you, sir? What do you do for a living? How much money do you make a month?
Como unos 3,000 a la mes.
All right, we're going to give you time to go hire a lawyer. So I'm going to have you come up here.
I have an
Oh,
attorney.
you do?
Sí, hay abogado.
What is this?
Androgen.
Oh, Androge? Okay, so this is what we'll do. I'm going to have you swear to us you're not going to drive. I'll get you to Victoria to sign a reset. I'll have you meet with Felicia for your bond conditions, and then we'll just have you wait in back for your lawyer to arrive.
Gracias.
Please.
Thank you, señor.
And he had felony court today, and so I advised him to come down here after felony court, just maybe more expedient. Overall, he's here in the back.
Come up, Mr. Lara. Are you representing him upstairs?
No, not upstairs, but I guess have learned that they have a TRAS set on the felony charge upstairs. He is made bond here on our case, and I think we need to get some bond conditions put in place. I talked with the state, we're amenable to no contact, no going near the protected address that is the subject of the individual.
I'm going to put a monitor on you, though. You're a flight risk, and you're on felony probation. You continue to do whatever you want to do when you want to do it. The court system doesn't work like that. And I'm going to tell you now, you ever take off on me again, I'm going to make your bond so high you'll have teeth falling out. Do you understand?
Yes, sir.
You will now get a leg monitor so we know where you are at all times. It's a GPS monitor. If you fail to charge it, I'm going to revoke your bond. All you're doing is enriching bonding companies every time you take off, because all we do is we revoke it, raise it, you're throwing money. So if you have a lot of free money, great. Do you understand?
Yes, sir.
You're not to have contact with the complaining witness. You're not to be in possession of any weapons. Do we know what is expected with the TRAS or no?
I don't at this moment.
No.
I think that just
When is the TRAS set for? Do you know? Let me see.
February. And I think the felony date set February 19th, if I'm not mistaken.
So I'm not going to hold this case open for that long, right? So we need to figure out a resolution here. So what I'll do is I'll give you, 3 weeks. When you come back, you guys need to let me know what you want to do. But there's no way that I'm holding this case open for that felony case. No, you need to decide what you want to do here. And then when you come back next time, you must either accept the plea bargain or I'm going to set your case for trial. Do you understand? Okay. All right.
Okay.
Gotcha. See you in 3 weeks.
Judge, did you want the, address to the exclusion zone as well?
Correct. Assuming that's the same